In fact, in this panel, we have 4 eminent constitutional scholars, and not 3. I was delinquent at the outset in failing to introduce Tara Kaitan, who is an associate professor and Hackney Fellow in Law at Wadham College. He is also Associate Director of the Oxford Human Rights Hub. He completed his undergraduate studies at the National Law School in Bangalore between 1999 and 2004. At Oxford, he was a Rhodes Scholar and completed his postgraduate studies, BCL with distinction, MPhil with distinction, DPhil at Exeter College. Before joining Wadham, he was the Pennington Student in Law at Christchurch. Taryn's monograph entitled A Theory of Discrimination Law is being published by OUP in May this year, so we'll look forward to that. His topic today is Transnational Perspectives on Indian Discrimination.
Thank you, Sarah, and thank you to all the previous speakers for their talks, and thank you to all. Before I start talking about my paper as the organizers hat on, maybe I should explain the references that the previous speakers made to the last 3 days, which might be puzzling to some of you. So for what we've been doing for the last 2 days is we decided to issue, Farhan and I decided to issue a call for papers, mainly targeted to very young Indian law scholars, people who are still doing their graduate degrees, to send proposals. And for the last 2 days we read 9 of those papers, which were produced and circulated to the closed group, and we've been commenting on those papers. So that's the reference that, and it has been an extremely productive exercise, and I hope to the authors as well. Anyway, the second sort of organizer's comment is this session was a residual catch-all session. Everything that didn't fit with the more thematic afternoon sessions was put in here, but I'm pleased to now see that there is a clear line that one can draw through the 4 presentations, from Cheryl's start on the basic structure doctrine as it's traditionally understood, to Paul's pointing out that there is an external dimension to the basic structure doctrine, in that it has been used in Germany in particular to define the self-identity of a jurisdiction. And I think there's a link to next presentation in when the Supreme Court rejects the use of comparative law because it's not relevant to Indian circumstances. I think one of the ways of framing the debate between the High Court and the Supreme Court is what counts as the Indian context. And autochthony, I think, as self-identity can be seen as the High Court seeing the constitutional basic structure derived morality as self-identity of the Indian legal system, and the Supreme Court taking a very different view on that. My paper follows on drawing upon these comparative themes, but also using Nick's particular example on discrimination law to talk about the Indian development in light of the development in certain common law jurisdictions. I've mainly looked at South Africa, Canada, the UK, and through the UK, EU law, and the United States, primarily because, as far as I'm aware, and I think conversations with colleagues from the civil law jurisdictions have confirmed, common law jurisdictions in particular have taken the lead in the late 20th century in developing discrimination law frameworks. My apologies to the Australians because of my own ignorance of the Australian legal system. That does not find a place in this study, and no doubt other relevant jurisdictions. So discrimination law is in some ways an anti-study in comparative law. An example where, with the exception of the Delhi High Court in the Nas Foundation case, how India has not looked at experiences elsewhere, or at least the more recent post-1970s experiences, not drawn upon that. my suspicion is the reason for that, and this is also true, again with a few exceptions that Nick pointed out, of the US. Now both of these jurisdictions, India and the United States, were the first movers in some senses on to deal with the question of discrimination, no doubt because of the most egregious forms of caste and race discrimination that these legal systems had to deal with. So they were thinking about the problem as early as in the 19th century and started developing an indigenous jurisprudence which took shape in the time to come. But perhaps because of the pioneers' self-confidence, the result in India has been, and I hope show this, an ossified domestic regime crying out for reform, something that the Delhi High Court abortively attempted to carry out in the Nas Foundation case. It is perhaps telling that the other pioneer, the United States, is also increasingly an outlier amongst these English-speaking common law-based liberal democracies when it comes to discrimination law. So comparative law is treacherous business, and I think if there's one message that I hope this paper will give it is that if Indian discrimination law is looking for inspiration and for its own development, contemporary US doctrine is perhaps the last place we should be looking at to see, or if we do, maybe to see how not to do things. But that may not be entirely fair to the US because there's an undercurrent which I'm a lot more sympathetic to. But anyway, I'll stop there. So what I'm going to present is a selective whistle-stop tour of development of discrimination law in these jurisdictions, organized. And what's also special about my choice of jurisdictions is that they've all exported or imported from each other, and inevitably with local adaptations, conscious and subconscious local adaptations. So this is not just a story of discrimination law, this is also a story of comparative law and trans-border travel of legal ideas and concepts. So I've organized the development of the doctrine on discrimination around three broad axes. The first is what duties does this area of law impose? And here we will look at the beginnings in the prohibition on direct discrimination and on provision for affirmative action, and the growth of these new ideas such as indirect discrimination, reasonable accommodation, protection against harassment, etc. In due course. The second axis to look at is who the duty bearers are, who carry the burden of these duties, and again the narrative is the expansion outwards from the state to the employers, landlords, housing societies, service providers, retailers. And finally, the third axis around which I've organized this development is who is protected, who are the beneficiaries of the law. And Owen Frisk predicted this. He already in 1970s he said that there's been a proliferation of the protectorate in discrimination law, and obviously he had not even seen what was to come in the next few decades, where it really takes off. But let me start with three very early theaters of development of discrimination law. And the first one, I'm even hesitant to call it discrimination law. It's probably the earliest prototype in ancient English common law duty on common callers, such as innkeepers, blacksmiths, and common carriers, to serve all fee-paying subjects without distinction. There's a case from 1701 called Lane against Cotton, where Justice Holt says, "If on the road a shoe falls off my horse, and I am come to a smith to have it put on, and the smith refuses to do it, an action will lie against him, because he has made profession of a trade which is for the public good, and has thereby exposed and vested an interest of himself in all the king's subjects, that will employ him in the way of his trade. Now this doctrine of the common callers, that they must serve whoever is willing to pay and satisfy the terms, they can't pick and choose, is then extended to all sorts of common callers, including the common laborer and the common prostitute in English common law. Anyway, I call it a prototype duty because it does not look like contemporary discrimination law. The first distinction is that it is not ground-based. Discrimination law today does not impose a general duty to serve whoever comes to you. It says what you cannot do is discriminate on certain protected grounds, such as race, sex, etc., and more on that in a moment. Even so, this general common law duty was relied upon in early to mid 20th century Britain, when, in the absence of any statutory protection, by Jews and blacks to bring anti-discrimination challenges, primarily against innkeepers. And there's a famous case of Constantine, the black cricketer who was refused lodgings in a hotel where the court relied on this doctrine to say he was wrongly refused the service. The second noticeable thing about this prototype doctrine is that it does not apply to the state. It applies to certain private professionals who hold themselves out to serve the public, and has thereby exposed and vested an interest of himself in all the king's subjects. So although it's non-state, there is a dimension of publicness in the idea of the common callers. Now, outside the prototype, if we can jump to the 19th century, the two parallel developments happening in the United States and in India. So to quickly rehearse a probably quite familiar American history, Dred Scott, 1856, the Supreme Court says blacks, whether free or slaves, are not citizens. It's a civil war, abolition of slavery. And then the 14th Amendment to the American Constitution, which overturns Dred Scott and guarantees, and I quote, equal protection of the laws to all citizens. There's no mention of the word discrimination. At least then it's not evident to anybody that equality means discrimination, the two go together, etc. And equal protection of the laws could have had a much broader, wider import than anti-discrimination. The very first case that the American Supreme Court decides on the 14th Amendment, the Slaughterhouse cases in 1872, firmly locates the equal protection of laws as an anti-discrimination guarantee motivated, given the historical context, of the protection of black people against prejudicial or hostile state action. Now, this is obviously, so the paradigm is set up. The task of this provision is to protect against direct discrimination by the state against a racial minority. It'll take, the US Congress actually passes the Civil Rights Act in the 80s to extend the protection against discrimination from private persons, which the Supreme Court strikes down as outside its power. It'll take almost a century for the US Congress to be able to do that again. I move quickly to India. We have the Caste Disabilities Removal Act 1850, which is still on the statute books, which says, which requires the courts to refuse to enforce law or usage which inflicts forfeiture or affects rights due to religious conversion or loss of caste. But the main action is an affirmative action from the final decade of the 19th century, which has a long trajectory, finally finds place in the Constitution as a consociational compromise between Ambedkar and Gandhi. Anyway, so that's the background. Late 20th century sees a remarkable development on all these three axes, and I don't have much time, so I'll go through it relatively quickly. Most of these expansions are happening in the US first, they travel elsewhere, and then there's pushback and rollback in the US. The first extension, so the key features of this expansion are these. The new statutes that come into play in the late 20th century in the US, UK, Canada, and South Africa, they're all civil in nature, not criminal. there's low standard of proof, and the victim gets something by way of relief. Indirect discrimination is invented by the US Supreme Court in Griggs and Duke Power Company. The concept, to use an Indian example, is essentially the impact of what you've done matters, not your motive. So the focus is on the suffering of the victim, not the intention or motives of the discriminator. So a housing society which says, look, we only want vegetarians, has a disproportionate impact on certain religious and caste groups, which would constitute indirect discrimination. Even if food preference is not a protected ground, religion and caste are, and that would constitute indirect discrimination. There's an expansion of the duty from the state to employers, landlords, service providers, and retailers. There's a proliferation of protected grounds from caste and race and sex to sexual orientation, disability, religion, age, marital status, etc. There's a heightened standard of judicial scrutiny of justification claims, and at least outside the US, a growing level of comfort with weak affirmative action policies, but which don't nearly approach the exceptional Indian scenario for special foundation reasons. Anyway, in this background, how does Indian discrimination law in the last half century compare? So the law has, the constitutional jurisprudence has largely focused on the scope and limits of affirmative action, primarily reservations in public employment and public education. Article 15 never really took off. There is no recognition of indirect discrimination or reasonable accommodation. There's an extremely deferential standard of review, which is the same as Article 14. So a law that distinguishes between, that puts a higher tax on coffee sellers rather than tea sellers is subject to a reasonableness standard of review. Exactly the same standard of review would be applied if there were different taxes on Hindus and Muslims, which incidentally is, I think, shockingly the case in India because of the legal recognition of the Hindu undivided family as a legal entity. So in effect, non-Hindus end up paying higher income tax than Hindus. Anyway, and the list of protected grounds in Article 15 is read as a closed list, and despite the language of Article 15.2, the duties applied largely to the state and not horizontally. The Delhi High Court tried to undo a lot of this, but obviously that has been reversed by the Supreme Court. The statutory discrimination law in India has not fared much better. There have been a few attempts to extend this to the private sector. The Civil Rights Act of 1955 and the Equal Remunerations Act of 1976 have provisions, criminal provisions, that outlaw certain forms of direct caste and sex discrimination in certain very defined contexts. So we have a scenario where housing societies across the country advertise with impunity, no Muslims, sometimes no Northeasterners, no single women, etc. The Sachar Committee, which looked into the status of Muslims in 2005, came up with a rather bureaucratic response of let's set up another commission to look into it. And the bill that was drafted by the Menon Committee in response to the Sachar Committee's recommendation, the Equal Opportunity Commission bill, remarkably just was entirely about setting up this commission, what it will look like, what its constitution will be, but there was no attempt whatsoever to expand the substantive scope of the law, to develop the doctrine, to say what rights people have. If you don't have any claim of discrimination against a housing society, I don't know what the commission would do. So India's problem with discrimination, I believe, is pervasive and urgent. Of course, Indian conditions are complex and unique, and any solution will have to be located in the peculiarities and pathologies of our local system. But any indigenous response should be informed by what has worked and what has failed elsewhere. I think South African friends tell me that the constitutional protection against discrimination has been remarkable and has done great things, but South Africa's statutory initiatives have not had much of an impact. We need before we do something about it to understand why. And I just finally want to reiterate the need to be suspicious of what I think is an overwhelming and disproportionate influence of American jurisprudence and American literature and American doctrine or in this area and others, and there are other places which are less troubled and less divided and less self-conflicted, where we might find more profitable ideas to learn from. Thank you.
Thank you very much. We've had 4 very thoughtful and thought-provoking papers, and now we have time for questions. If you wouldn't mind, please, when you ask a question, just to identify yourself and maybe say to whom your question is addressed. If you wouldn't mind, please, keeping your questions or comments short, then that will give everybody a chance to participate in the discussion. Thank you. Professor Bakshi, I think, has a question.
Open Bakshi, my name, if I may exemplify brevity with Chair Oswald. First of all, welcome to you all. We are from Delhi University and Warwick. Well, I concentrate only on 2 presentations, giving the want of time. On the first presentation by Professor Craig, I just want to know, there are clearly ontological, what you call meta questions involved. What is the being of a nation? What is the identity of the Constitution? What is wrong with the older doctrines of margin of appreciation and of subsidiarity, which unfolded quite substantially to do the same job as would seem from the outside, the identity discourse seems to do. Whose identity they are protecting? That of the legal order of the Constitution or of the judicial process? That is the main question I have. The ontological, they're not protecting nation's being, ontology of the nation. They're not doing ontology of the population. They're not talking about the Turks in Germany, for example. I'm focusing especially on German court. They're only focusing on their being. The power of judiciary, and in that respect, they're very close to basic structure. Basic structure in India means nothing else than the power of the judges to say what the basic structure is. So that's the, and I welcome it. I am all for it. I want to understand it from you as to what is the distinctive step they've taken from subsidiarity and other principles of margin of appreciation. On the next presentation, I think only very quickly, the court should not have heard the second appeal, because the court by written order mandated the Delhi High Court early on to study the matter in all its aspects and the work and pass the judgment. Therefore, what I call last two kaushal is wrongly decided. The court did not come to, Supreme Court did not come to picture because Supreme Court divested itself of the jurisdiction. The PIL was originally filed before the Supreme Court. It gave it to Delhi High Court and it gave direction to consider all aspects and decided comprehensively. And that's what the High Court did. I hope that my lawyer friends will argue with the petition that is now called Supreme Court. What is called? Petition is called curative petition. But coming to that aspect, which I have not noticed, the kind of reliance on foreign judgments. And I think you bring out the irony very well. The Supreme Court itself relies very heavily on foreign judgments, particularly American. And Supreme Court wanted the High Court to refer to foreign precedents when it said comprehensively. So there is a double irony involved in relying on foreign precedents. But my short question is Kaushal decided by the Supreme Court on the ground of insularity or on the ground of severability. That's the question I have. I have not asked very much.
Professor Bakshi, thank you very much for the very interesting and excellent question. Very briefly, because of exigencies of time, my response would be this. There's no doubt that notions of subsidiarity and margin of appreciation are themselves legal doctrines which have an impact on or play into ideas of autonomy. No doubt about that, I wouldn't deny that at all. The answer to your question, which I took to be, why isn't that enough? In what sense do we require more? And the answer to that is, in relation to the UK and the ECHR, it's quite clear that a number of the judges feel that that isn't enough, that that's not sufficiently protective of autochthony as defined in terms of national traditions and national values. And that may not be enough either because the margin of appreciation is regarded as too narrow, or the conception of subsidiarity is not regarded as broad and comprehensive enough. But it's quite clear that in relation to the specific cases where the UK judges have got upset, like the prisoner voting kinds of cases, they do not regard, in that sense, standard doctrines, which do, I accept entirely, play into ideas of autonomy. They don't regard those as sufficiently protective, which is why they're pushing back and wanting more. The second response is that certain of their concerns about the ECHR, whether valid or not, but certain of their concerns are not touched by subsidiarity or margin, howsoever you define those terms. In what sense are they not touched? Because part of their concern, like Lord Sumption and Lord Hoffman and Lord Judge, is about an over-expansive interpretation of the substantive reach of the Convention, which they do not believe is justified, and which therefore leads to an impact on national freedom of action. And that dimension, once again, is not touched by subsidiarity or margin, howsoever defined.